All right, I am now recording the event. All right, we have convened today for a public deliberation as is required by the code in Board of Appeals case number 2020-0309, that is 2429 Lightfoot LLC. There was an appeal from the administrative law judge, and there was a full de novo evidentiary hearing heard before this board. As was requested, we received very well written, cogent, and well thought out legal briefs from both petitioners' counsel and protestants' counsel. And thus the hearing that we had involving these parties were also well done by both counsel in helping this board come to its conclusion. For folks who might be listening, we are appearing via WebEx. This is a public deliberation that prior to COVID we would have had in the hearing room at the Board of Appeals. We would have sat out at a conference table where the public would have been free to attend. They would have been allowed to listen to our deliberations, though they would not have been allowed to participate. So we are having this via WebEx, so folks can actually come on and listen to our deliberations in this matter, but there is no further argument or evidence heard during these public deliberations. The case before us today is a petition for special hearing pursuant to section 500.7. A petition for special hearing is akin to a declaratory judgment that you might find in the circuit court, where a petitioner has asked us to rule on a specific rule of law. In addition to this petition for special hearing, there is some requests for variances as well. The case before us, from the facts that I can recall to share, and my colleagues can add to them as they have their turn to speak, we have a request for a synagogue in a residential community, residential zone. We heard testimony that it previously was a home, a residential house. In some cases, we have to basically look into the crystal ball as to how things are going to work at a certain place. We didn't have to do this in this case because of course, there had been prior use of this location as a synagogue. Important evidence that was presented was this is a Orthodox congregation. As the tenets of the faith mandate on Sabbath, there is folks who walk, who get there by foot. Important factor was brought up by Protestants Council is that there is often gatherings at this location, high holy days that in fact may not fall on the Sabbath, that would allow congregants actually to drive. We heard testimony that a majority of congregants lived within the immediate area, perhaps could walk. But we also heard testimony that there was either prior use or intended future use of parking facilities at an adjacent elementary school. We also heard testimony from the community who described the community, basically typical residential community. There is street parking in this community. We heard testimony that the roads were rather narrow, that there had been accidents up at the corner, though there had been no nexus made between those accidents and the use of the property in question. But it was quite clear that it was a residential road. It was quite clear that there was concerns that although they realized that many folks were going to walk to this location, that there would be increased traffic and increased parking on an already limited parking situation. We also heard testimony, I believe, from one adjacent neighbor who complained that sometimes congregants or children thereof ended up on the property or in the yard and things of that sort. So that testimony was given as well. So often cases before this board are very fact intensive. There's disputes as to facts, and we have to kind of mill through testimony to find out the facts. I say this case is a situation where it is the law that is basically at issue rather than the facts. I think we all agree pretty much what the facts are, the use of the property, the collateral issues with that use. So the relief that was requested through the special hearing is for us to interpret the BCZR 1B01-.1B.1H. And that's the last time I'm going to say that because that's a tongue twister. But basically, that is the provisions of the RTA, residential transition areas. And those who might be listening who are not lawyers, why that's important. The county council at some point in time determined that there should be basically buffers in residential areas between residential construction and the construction of other type of housing types. I guess the best example would be if you were going to do an apartment building or something within a residential neighborhood, that there'd be certain buffers that would be greater than standard buffers found in that particular zone. The language of this statute is what is very important for this board to interpret. So again, for those who aren't lawyers, this board interprets the law. The county council is the one who makes the law. Often, the law is not made all at one time. So sometimes new laws sometimes contradict with old laws, things of that sort. It's our job to figure out which one applies and how it is to apply. One thing we do know is clear that this is a DR 5.5 zone. We know churches are allowed as of right. And what that means is basically for a zone, you have a list of things that can just be there by right. They don't have to go to any legislative body to request permission to be there. They are there by right. There's other things listed by special exception, meaning they might be allowed if certain criteria are fulfilled, and a board such as this one would make that determination. But in this case, churches are allowed by right in a DR 5.5. So now we have to deal with how that deals with the constraints of the RTA. And the RTA, in its language, in the citation that I just listed, makes the gatekeeper for whether there is application to this law being whether or not there is to be development. And that is the gravamen of all concern, is whether or not there is development. Now, one benefit of being on this board for a very long time is you're confronted with the cases that you decided a very long time ago. And that's why in our hearing, I had a particular concern about Lucy Ware, the People's Council of Baltimore County. And I believe I was the author of the opinion before the Board of Appeals when that came through the first time, went to the circuit court, was upheld, then went to the Court of Appeals and was upheld there. There are several other Lucy Ware decisions when other issues were kind of interjected into the analysis. The reason that I was concerned about this Lucy Ware decision, and I believe the petitioners noted my concern in their brief, was that this case was purely a zoning case. The issues that came later, dealing with our Lupin, things of that sort, were not yet on the table. So it was interesting to me to see what the Court of Special Appeals said concerning the interpretation of this statute without any other issues being basically considered. Now, often in the discussion of the statute is whether or not it's development that triggers the statutory constraints or whether it is a change in use. And it's often thought when thinking about I guess we'll call it Ware 1, is that the Court of Special Appeals somehow found that the change of use was the trigger for the RTA applying. And as Petitioner's Counsel brought up in his brief, a very close reading of that case is that's not what it said at all. It basically got to the heart of the statutory interpretation, and that's why Petitioner's Counsel cites Marzullo v. Call, the Merit Employees Federal Credit Union, and Kowzerowski, which you don't always see in these briefs because this deals with statutory construction and basically the plain meaning rule. The issue for development that was brought up in Lucy Ware 1 was the fact that there was a parking plan that created a new gravel parking lot. There was grading There was landscape details that were going to come forth. The court even brought up the fact that the appellants in that case were arguing that the board, we looked at the wrong meaning of development. We actually looked at the meaning that they cited, and then they decided they had cited the wrong thing. We should have looked at the dictionary. But the intent of statutory construction, if there's an ambiguity as to a term, you look elsewhere in the code. So the development in the code, we can say that the turning of dirt, the turning of a shovel sometimes could be development. A parking lot could be development. So in Lucy Ware, one, it was not the use, the change in use that was triggering the RTA. The actual thing that was being determined is whether there was development, albeit so slight, which turns us to the facts of this case, the very unique facts of this case. And I say that because sometimes unique facts make bad decisions and bad law for precedent for those who don't understand the distinction. But we have very unique facts. And the unique facts that we're dealing with in this case is that the plan that has been presented both below and before this board, there is no external alterations to be made to this property. There is no building of parking lots. There is no turning of dirt. There is nothing that is being done to this property. Everything that's different maybe is inside. I can't even say that it's different because it's really already happening. So the distinction between Lucy Ware and other such cases is that in this case, to me, is that in fact, there is nothing going on here that would constitute the definition that the Court of Special Appeals has given us guidance to find development. Going to the second facet, there are exceptions, even if there were to be development. And the one exception is interesting is for churches. So the county council, in making this statute, determined that perhaps churches may be different and treated differently. Again, the exception itself uses the term development again. So we could stop this there and say we don't even have to look at the exception because there is no development. But then again, if we were to find there was some development and look at that exception, there has to be a finding by the finder of fact that basically everything that could be done is being done to keep it in compliance with the nature of the community and things of that sort, to put it lightly. To that point, there's nothing that can be done or is being done because the house is being a house. But the second factor of that, to say to keep it in keeping with the nature of the community, brings us back to the fact that in DR 5.5, churches are allowed by right. And what that means is that any effect of a church, i.e. the traffic on a Saturday or a Sunday or whatever, depending on the denomination, is baked into the cake, meaning that county council understood that there would be people coming into that community at certain times for the use of religious worship. So for me, that exception, even if there was development, I think would be satisfied. As to the third exception, the exception that's been brought up by council, I think dealing with the prior plat, prior zoning, things of that sort. I'm not going to go there today because I'm not prepared to go that far, and I don't need to, because the way I see things, in keeping with Lucy Ware People's Council, which, just to be clear, there was a second Lucy Ware that was an appeal based on a finding of dismissal based on res judicata and alternative theory. So in my eyes, this, at least the analysis used by the Court of Special Appeals, is still a good analysis for my use. So that's where I come down on that application of the RTA in this very, very specific set of facts. And I want to be clear that I understand that there is conditions on the ground that the community is not happy with, and I understand why that is. Unfortunately, what I'm dealing with is what has been contemplated by the council. And when I do a reading on the plain meeting and the statutory construction of the plain meeting of what I'm seeing, I'm clear in this case, not to say other cases, that there is no development to trigger the RTA for the first group of RTA variances that were requested. Just to be clear, we have the petition for special hearing. We have step one, whether or not the RTA applies. If it does apply, there's the variances from the RTA requirements. And then there's two other parts. We have the parking plan, modified parking plan, and then we just have these standard variances that are sort of baked in due to the fact that this is a pre-modern zoning house and structure. So there's non-conforming structures already on the property. That is often the case. And what practitioners often do is they bring those variances just to get basically a rubber stamp for the future. So those things have been taken care of because today they are in non-compliance. So what I'm going to do is I'm going to stop talking because I've talked a lot and I apologize. At the RTA issue one, hear from my colleagues before we then get into the standard, the variances, and the modified parking plan. I can just say right now that in keeping with my thought of the non-application of the RTA, I would grant the modified parking plan as required, and then go on from there. So I'll let you folks, whoever wants to go next. And have I muted? Fred, did I mute you? I'm sorry, sir. Mr. Lauer?
Yeah, I'm good. Mr. Chairman, let me just clarify here and understand. So you're saying that in looking at Lucy Ware and looking at the code provisions, that only exterior changes mean a change in development. That's really what you're saying, right?
Yes.
Okay. And you said a house is still being a house, I think. And this house, though, is being a synagogue.
That is true.
Okay. And this was set up as a, quote, residential development in the 1950s, 58 or whenever it was. And the change, as you see it, is a change in use in the exterior or interior only, and it doesn't trigger this, this exterior change really doesn't, is what triggers this development clause that we're talking about. I'm just understanding here.
Yes, and alternatively for what's your analysis, if in fact, I guess arguendo, if in fact we were to determine that development was triggered by some other use or mild change inside, that I would be convinced that the exception that is provided for churches would be fulfilled due to the fact, one, there's a finding of this board that really nothing more could be done. But second of all, that the fact that it is a use thereof right, that it never really was in contrast to the residential zone because it's included as a allowed by part of that zone to begin with.
Okay, I'm just understanding. I looked at Lucy Ware and I've looked through the code, etc. And I guess we'll get on to the other parts of that. But thank you. I really appreciate your understanding and expertise with this matter.
Understanding would be hyperbolous. That would just be my interpretation, I guess we can say, based on I can tell you how I remembered Lucy Ware 1 was different than what it was. It'd been some time, and it was always sort of in my mind that there was a use component to the triggering of the RTA. But I mean, you know, I printed it out, so I had it in hand, and a deep dive from what the court was saying was they were really getting into what is development. And there was facts on the ground, i.e. this. So in Lucy Ware, there was a parking lot that was being made, I believe in the rear with gravel. That parking lot itself was going to place itself pretty much in proximity to neighbors themselves. So the traffic coming in that location would in fact really affect the use of the property as well with the vehicular traffic inside on the property with the neighbors. That was very much development. You know, we have found development to mean, you know, you're doing grading, you're turning shovels. So that type of situation is very fact-based, which made me examine the very limited nature of this case on a fact-based analysis on whether or not there is development. And I gave it an honest assessment, and I guess in a strict constructionist sense. Um, and that's, I try to be consistent. And it's interesting in the Lucy Ware decision, they bring up the point in a footnote that we are not bound by our own prior decisions. And that issue comes up in another case that I was on, was the Sonic on York Road, which we also had waived the RTA requirements. But the difference in that case was it was split zoned. And I seem to recall that the portion that was residential that would have triggered RTA was not being developed per se. And that was another very factually unique scenario. And the Court of Special Appeals had called out that that was a factually, even though you had to read the footnote, a factually unique scenario. So that's the basis is, you know, I did some homework as to the case law. Interesting point that's brought up by petitioners counsel. Often when you're doing a legislative history, the exceptions that are in the RTA are there very much on purpose. And the reason we know they're on purpose is because once they messed up and they left them out, and they very quickly fixed that mistake and put them back in. So that's pretty good evidence of, you know, the county council in the RTA saying there were exceptions to this. Now, I'm not saying this is the most ideal situation or that it even makes the best sense, but that is the job of a legislator, not a quasi-judicial officer interpreting statute.
I got it. Thank you.
Mr. Pennington, sir?
Yeah, and Mr. Belt, thank you for your thorough analysis of the case to this point. I actually agree with you. I read through the Ware opinion, and the courts clearly, you know, stated that adding that gravel lot in the back of the pretty sizable parking lot, if I recall, and then they planted trees and did the landscaping to sort of try to buffer that parking lot. That's development. And I don't see that in this case. So I think there is a clear distinction between this case and the Ware case. So I agree with you, and I wouldn't even get to the exceptions of the RTA. I think there's no development here.
All right, so before we proceed to the other issues, do we have a voting consensus as to issue 1, whether or not we are delving deeper into RTA variances or whether or not we are satisfied? And I keep saying this because it's terribly important, the very unique facts of this case and their application to the RTA.
I'm with you, Mr. Chairman.
All right, so there we are. So that removes some things off the plate. The next issue was the modified parking plan. Basically, it's a statutory requirement. petitioner's counsel laid out some different ways we can get to where he wants us to be. I find that once we have made the determination that in fact we have the use of the church being allowable basically by right, that there would be quite an undue hardship if there were to be a strict application of the parking requirements. And again, the community would not want it to have the parking requirements out on the road or somewhere else. Another unique set of these facts is the fact that this is a pedestrian driven attendance. The concern is on, I guess, high holy days that would not fall on Sabbath, and there would be traffic. The point evidence that we heard about the possible parking off-site was something to consider, and I think is important in this case, though not dispositive. But I am comfortable with the arguments presented and the information provided through the petitioners. I think it was Mr. Motzko's testimony to grant the requested modified parking. Mr. Lauer?
Yeah, Mr. Chairman, how do you see this property as unique?
The uniqueness is, I was going to go to the second part for that. I guess if you want to join that. So the testimony of the Mr. Motzko dealing with uniqueness was, as was mentioned before, there's some grading uniqueness, some shape uniqueness. Basically, I was deferring to Mr. Motzko's testimony in that regard. Often in this case, to be completely honest, in the finding of uniqueness in this situation, when we're dealing with, and I'm talking about the variances requested as to the shed structure and the original, we're dealing with basically a non-conforming property the way that it is right now. Meaning that when it was built, it was not required to conform to those standards. That probably could be the case probably for almost every structure that you would find in the surrounding area. There was, a brief testimony by Mr. Motzko as such, dealing with the grade and shape, and that's what I was hanging my hat on to that, in that these variances themselves are really not the biggest issue that we're dealing with.
Okay.
And I guess, and the second, though it's not the proper analysis, the second situation into that situation is that if, say, you found that you can't have the variances for the conditions that are on the ground, I guess the short code enforcement wouldn't go this far, but the only remedy would be to remove them. So that would, I would say, be a pretty serious hardship for a structure that's built in a non-conforming status due to changing zoning law.
Okay, thank you.
Okay. Mr. Pennington, sir?
With the parking and with the setbacks. And I know you probably didn't get to the side yard setbacks yet, but I mean, I agree with you for the shed. I think it's what, 0 inches and then maybe 18 as opposed to 30, and then the front and the side. So I agree.
Yeah, I can just say a matter of practice that the reasons that those variances are presented in this matter are of a housekeeping nature, in that since there is a case dealing with them, that the due diligence of counsel brings them forth just to bless conditions on the ground that now exist under the new zoning law. So the analysis that might be required in granting those might be different in a different situation, but that's That's what I can say about that matter. Is there, so, Mr. Pennington, you're on mute at the beginning. Did you have a comment as to the request for the modified parking plan?
No, I'm sorry, I was muted. No, I agree with you for the parking.
And
I agree
Mr.
also, Mr. Chairman.
All right, are there any other issues of concern that would need to be raised by any member of the board before we sign off?
Mr. Chairman, do we need to officially vote on the other variances, or is that?
Oh, I didn't take an official vote. I was mental tallying. So I'm not going through the variances specifically. I'm just going to say the requested variance relief as so listed into the petition by the petitioner, describing basically the pre-existing conditions on the ground and also the modified parking plan. I am in favor of granting those in light of our prior ruling.
I agree.
I'm with you, Mr. Chairman.
All right. In summary, I do feel it necessary to, describe this, to explain to folks, again, as I stated before, each case is unique in their facts. Those facts are then applied to the law. The situation that we have here, those supported by some and opposed by some, we understand that folks have their concerns, and perhaps those concerns need to be dealt with in some other type of agency other than themselves. But our charge here is to apply the facts in this case to the law. And in this case, we had a very cogent and clear presentation, both by petitioners counsel and by protestants counsel, who did a fabulous job of informing us as to the concerns of the neighborhood and making the strong arguments that what should be made in this matter is that it seems somewhat inconsistent to what we believe to be practical. But in this situation, we have our charge, and our charge is to apply the law. In this case, we were lucky enough, we just didn't have to look at our own prior opinions. We had the benefit of a Court of Special Appeals opinion that really provided some clarity into a very muddy situation. And through that guidance, we have based our decision. And thank you both for your contributions. I thank the community for their participation and thank council for their very helpful presentations on both sides. And with that, I'm going to hit the stop button and we will, for folks who are wondering, the decision itself will be done in a written decision. That written decision will then be mailed out to the parties. The proper instructions as to time for appeal for further review of our decision in the Circuit Court for Baltimore County is laid out at the end of that decision. So we will have a opinion coming in writing in due time. And with that, I'm going to sign off. All right, recording is